Hello, I want to share with you the content of a recent webinar I ran that looked at preventing sexual harassment in the workplace. Now, this is based on UK legislation and taking a look at what employers should be doing now, as well as looking forward to changes which are coming up in October 2026. If something resonates for you in this presentation, or you want to ask any particular questions around this, you're looking for help, then there will be a QR code at the end where you can connect with your local HR department licensee, and they'll be able to help and support you, as well as guide you through what you need to do, not just with this particular change in the Employment Rights Act, but any changes within the Act that are coming through 2026 and beyond. I hope you enjoy, and I'll see you soon.
So what I want to do today is walk you through things that should be thinking about now, as well as changes which are coming up later in 2026. So it's all about preventing sexual harassment in the workplace. Not to say that's the only change that's coming, but that's the purpose of today. And I don't envisage this going longer than 30 minutes in total. But if you have any questions, please raise them in the Q&A. I've got some time towards the end to cover off anything that you've got that crops up. So in terms of this session, I'm Heather. I'm the owner and director of the HR department, Carlisle and Morecambe, and I help all small and medium organisations with up to about 100 employees, anywhere from Carlisle to Morecambe, on the HR side of their operation. So anything in relation to people. I don't cover health and safety, but I know folks who can. For today, this is really what we're going to dig into, is understand the legal position today and the responsibilities that come with that for employers, look at the practical steps that you can take, maybe look at now, as well as look at the changes which are proposed through the Employment Rights Act. I just want to take a wee bit of a step back, because October of 2024, there was quite a change that came in, and that was a change to the Equality Act in relation to employers now having a legal duty to take reasonable steps to create a safe working environment. That duty includes to anticipate when sexual harassment may occur and then put preventative actions in place, as well as, if it's happened, to take action and stop it from happening again. So that's the kind of the framework, the environment that we're in at the moment, and this is what we'll tweak and change as we head through the rest of the year. So what could we be doing now that's really going to get us into a good place? Well, there's a few bits and pieces here. One is to make sure that any standalone bullying harassment policies are fit for purpose and reference sexual harassment and provide an appropriate route map if you don't use your standard grievance procedure for dealing with those kinds of complaints. And if you don't have a standalone policy, make sure that any employee handbook you have covers this adequately. So that's really a good start point for you. Engaging with and briefing your team so that they understand what is not acceptable. And that's not just for sexual harassment, that's for a range of things, but make sure that they understand not just what is and isn't acceptable, but also cover what they can then do if they are subject to or notice anything. In addition to that, think about what training you can provide, and that's for employees as well as managers, in terms of making sure that you cover off your legal duty by training those in your organisation. That's a way that you can show that you are meeting your duty. Third party harassment, I'll come back to in a moment, because there's no direct claim that somebody can take for third party harassment at the moment, but there is such a thing known as vicariously liable, in that you as an employer can still be vicariously liable for the actions of a third party, even if you had no control or remit over that third party and their behaviour. So it's something to be aware of. That will be changing, and I'll mention that in a moment. Clear reporting is a key part of this. Is if there's something crops up, how does somebody report? Do they understand? Do they know where they're to go? Is it easily accessible and easily understood? We need to monitor and evaluate what we have in place and tweak as needed, and understand, well, is there a particular location that we might need to take a look at, maybe a particular team, a supplier, a customer, whatever that is, we should be keeping that under review. And a key, underlying all of this is risk assessing, making sure you understand what the risks are associated with sexual harassment, as you should be doing for various other aspects of operations anyway. So this is all kind of the bedrock, the foundation for what we should be doing now, based on the changes back in October 2024. There are some common scenarios that could crop up. I mean, given where we are, time of year, unfortunately, when alcohol comes into play, that's when things can happen. Christmas party being one of them, a team event could be another. Just be mindful that could be a situation, but also maybe being too friendly with work colleagues, direct reports. Do you have a work WhatsApp message, a group message? In which case, how are people responding to each other? What words do they use, descriptors they're using? And if something crops up that doesn't look or sound right, then we need to be dealing with that. Also, think I did mention third party harassment, customers, clients, suppliers. Think about that, because that should also be part of your risk assessment considerations, as well as agency workers. So anybody that you've got working in your facility in whatever way could still, you still need to consider what the scenarios are. Are we briefing them appropriately? Do they understand what is and isn't acceptable as part of our induction processes? As well as, at what point might they get involved in our workplace, and might that provide additional risk or things we need to think about? So this will all form part of your considerations. I mentioned risk assessments. This is a foundation element, really, and completing risk assessments will help you comply with the duty, because you're going to be looking at who's at risk, how are they at risk, and then what controls you can put in place to mitigate those risks. Because it's not just the who and the how, it's what are we actually going to do, and have we done it? So yes, identify the potential risks, implement the controls, and then regularly review. So more often than not, you'll have a range of risk assessments that you have in your organisation that you're following up and reviewing on a regular basis. This should just be part of that review cycle, in addition to, maybe manual handling risk assessment, COSH, all the usual ones that you might find. So let's have a look at, if you do have a complaint, and at times there may well be complaints that crop up, take it seriously. This isn't something just to say, oh, that's just them, and put it to one side. Use your standard grievance procedure and follow it as you would normally. So act immediately and protect the complainant, and that might mean needing to separate the parties for a time. It might mean going a wee bit further, maybe suspension. It all depends on your standard process, and if you need to, if you have something crops up, take advice, chat with somebody about this, because you want to make sure that you're doing the right things. Always make sure that whatever your process is and the responses that you have align with your company policy and or procedures. That what would we ordinarily do in this situation? Because if you go and do something different for one person than another, that might not be the appropriate response. We need to be communicating the outcome fully to make sure we're not going to be breaching any confidences, but make sure the complainant understands what's happened and what the next steps are, and keep those records. Yes, we need to be mindful of data protection regulations, GDPR, in that only those who need to have access have access. But if you need to do any future analysis, that will help you with that. And also, you should be maintaining records for a period anyway of employees that you have and past employees. Now, if we don't act, it's worth being aware of this. So if we fail to act, somebody's can put a complaint forward, we fail to follow up on this, and they take a claim through a tribunal, then a tribunal judge has the option of, if the claim is successful, they could up that claim by up to 25%. And it is up to the tribunal judge that hears the case to decide on that. It's not a definite, but they have the option to do that. There is also the option of the European Human Rights Commission Enforcement Act to investigate and issue an unlawful act notice. We honestly haven't seen too many things come through the court system at the moment, mostly because the court system is so backed up. But also what we may find is when a case like this is, when a claim is lodged, it's unlikely to be just one thing that they've put as a claim. They could have sex discrimination, sexual harassment, you could have unfair dismissal, there could be more than one thing. And some organisations might be more willing to settle to save some of this happening. It doesn't always end up that way, but that could be a reason. But I'm keeping, we've not seen too much come through. However, there are cases that have been in the news that we've heard about. I'm sure you'll have heard about the McDonald's situation. So that's where we are at the moment. And those are all things that hopefully it could be some thinking there in terms of, well, we need to have a look at our policy. What training are we doing? Have we done the risk assessments? And those are the key foundational elements. Let's have a look forward to October of this year. So 2 years after the original changes came into force. There will be a change. Currently, we need to make sure the duty is reasonable steps. Come October of this year, the legal duty will be to take all reasonable steps to prevent sexual harassment. I'll talk about reasonable steps in a moment. Now, this change in October does include third-party harassment, so it's worth being aware of that. So employers will be asked to take specific steps where they're proportionate and there's an evidence base about their efficacy in preventing workplace sexual harassment. Many of them are the things that we've already spoken about. We'll have to see if there's anything else that the government recommends. The other thing to be aware of is having folks sign a non-disclosure agreement to silence victims will no longer be lawful come October. So your whistleblowing policies will need to, or might need to be reviewed at that point. Any larger employees, there might be additional actions, but that's, those 250 employees plus. There's also potentially going to be, well, there's something slated for 27-28 implementation, is a regulation defining what the government means by reasonable steps. Often we find that when employment law or any law comes in, it's only at the court decision do you really understand, have we implemented it correctly? Have we interpreted a particular phrase as the courts, the courts would do so? Not always the case, because it's not always clear. In terms of reasonable steps, here we go. So there is a fact sheet available on the government website on this. If you wish to take a look, it is readily available. The things that might come through the regulations, we don't have any insight on this at the moment. Consultation will need to take place first, but it more than likely going to be carry out an assessment, publish plans or policies, and define and communicate how folks would report sexual harassment and how you'll handle them. So that's all stuff that we've already spoken about, but it's entirely possible that we might need to tweak our approach based on any regulation that is enacted. I think the sentence at the bottom is an important one to be mindful of, in that an employer that wants to show that they've taken all reasonable steps must take the relevant steps as set out in these regulations, as well as any other preventative measures or steps that's reasonable for them to take. Now, unfortunately, that's a wee bit of a catch-all. It's not terribly helpful, but it is not just what's in the regulation. If there's something else that you should do because of the industry, the location, the size and scope of workforce, then do that as well. But only really you'd come to that understanding, I think, having done a risk assessment or seeing what comes through or what you're noticing as we move forward. So in addition to those bits and pieces that we've already spoken about, come October is again review the anti-harassment, bullying and harassment policies, whistleblowing for sure. Think about refresher training for managers and workers. At that point, the prior changes will have been 2 years old, so you should be thinking about how we refresh folks on what their responsibilities are and what they can do if they are subject to or notice sexual harassment. Make sure you keep written records of the training provided. So if that's classroom-based training, make sure you have a signature sheet. Be good if I could speak. If it's e-learning, you should have those records. Understand keep the records for investigations and any follow-ups and any adjustments that you've made. And the other thing is, think about third-party contractors, the relationships that you have with them. Who are they? What T's and C's or terms do we have in place with them? What flow down of our policies and procedures do we have to our suppliers? Because you do need to bear in mind that will come in October.